let you all know that this session is being recorded and the recording has now started. If you have not muted yourself, we ask you to please do so. We will not tonight be able to invite folks to speak because we have such a large audience, and it is going to be very, very difficult to find out who's in what order and what your questions are. So we are asking you, if you have a question or a comment, that you please use the chat box, which is located at the bottom of your screen or at the top of your screen, depending on whichever system you're using. So good evening, everyone. I'm delighted to welcome you to our membership event tonight, with the topic being wills and estate planning. I'm Sharon Callahan, the Executive Director for the Pensioners Association, and I will be one of your hosts for this evening's session. I want to thank all the members and others who have participated in our recent events. It is most encouraging and confirming to us when we see such an uptake on the topics that we have offered by such a high registration for these events. But this event tonight is momentous, and is particularly confirming to us, as the registration level for this event tonight has reached a number higher than we could ever have expected, and is the highest we've ever had for an event such as this. So thank you all for coming tonight. Clearly, this is a topic that all of you have a particular interest in hearing about. This evening's session is offered in partnership with Provident 10 and the Public Legal Information Association of Newfoundland and Labrador. And this is the start of a stronger relationship between Provident 10 and the Pensioners Association, and we expect to offer more sessions in partnership with Provident 10 on a go-forward basis. Before we get started, though, I do need to take a moment to go through some housekeeping items for you. First of all, and I'm going to emphasize this, it is really important that you mute yourselves during the presentation and stay muted unless there's some recognition of you by the chair. Any noise, background noise at all, is going to interfere with the hearing capacity of other persons on this call tonight. So we hope that you are situated or located in an area in your home or wherever you are that is quiet, and you avoid any background noise. So if you're in the TV room and NTV or CBC News is on, you need to move or turn off the news, because this is more important than the news is going to be for you for tonight, right? If you've got an additional device close by as well, like a cell phone or an iPad and a laptop, there could be some technical interference there that could impact your hearing on it. So you might want to just move them apart a little bit. Again, as I said when we first started, use the chat box for any questions, and we'll get to them as best we can. If not, as I indicated, the session is being recorded, and we will see what we can provide in way of answers to you. So I now invite Wayne Noseworthy, the president of the Pensioners Association, to offer a few words of welcome to you.
Thank you, Sharon. First of all, I'm delighted to be able to take part in this particular event. As some of you might know, in one of my previous lives, I had about 12 years developing and presenting pre-retirement seminars, and wills and estate planning was a key element of that. So I'm really looking forward to what Sara has to say this evening. So first of all, let me welcome everybody. We are really gratified, as Sharon indicated, with the huge response, the tremendous response for those participating tonight. I particularly want to offer my appreciation as president to Provident 10 and the Public Legal Information Association for assisting and making this particular evening possible. We're really thrilled to be part of this, so thank you so much. And I guess I should thank Sara in advance. I want to steal her thunder, and I'll now go to Leona Barrington. Leona is Director of Stakeholder Relations at Provident, and I'll ask Leona to introduce Sara. Thanks very much.
Thanks so much, Wayne and Sharon, and welcome, Sara. It's a pleasure to be here tonight and represent Provident 10. For those of you who may not be familiar with us, we were established in 2017 following the province's pension reform. So we're currently one of Atlantic Canada's largest pension funds with $11 billion under management. And we have 55,000 members. Approximately 28,000 are active members, so actively contributing to the plan through their employers currently. But we have approximately 23,000 members that are pensioners. So I'm thinking a lot of you are on the call tonight. So thanks so much for joining us. At Provident 10, we're really focused on trying to create open dialogue around financial wellness and financial planning. So when we started to think about what we may want to do around Financial Literacy Month, which happens to be the month of November, I reached out to Sharon and asked if there was anything she felt her members would be interested in hearing about as it relates to financial planning. And we felt that estate planning might be a great fit. And sure enough, as Sharon said, and Wayne alluded to, the attendance tonight certainly demonstrates that. So it's great to have you all here. I thank you very much. And as Sharon said, we hope to partner with the association moving forward on more events like this, and which we're really excited about. And so now, without further ado, we'll dig into why we're here. And I have the pleasure of introducing Sara Hawkins. So Sara is a Access to Justice Coordinator with the Public Legal Information Association of Newfoundland and Labrador. She has over 15 years experience as a paralegal and has worked with private firms, legal aid, the courts, and nonprofits. She has a deep passion for seniors who need help navigating the legal aspects of aging. And when not at work, Sara is a volunteer first responder with St. John's Ambulance. And I also hear she's a pretty big Growlers fan. So I'm sure there's a bunch of Growlers fans on the call tonight as well. So Sara, thanks so much for joining us and for taking the time to walk us through all things estate and will planning. So over to you.
Welcome, everybody. I'm so glad everybody's here. So I just shared my screen. And just give me one more second because I need my notes. All right. So good evening, everybody. My name is Sara Hawkins. I am an Access to Justice Coordinator with the Public Legal Information Association of Newfoundland and Labrador. And tonight you are here to do a quick overview of wills and legal planning. So today we're going to talk a little bit about what is the Public Legal Information Association, what we do, and what we can offer you. Then we're going to talk about wills and estates. We'll talk about enduring power of attorney, and we'll talk about Advanced Health Care Directives. So what is the Public Legal Information Association? We are an independent nonprofit founded in 1984. And our goal is to educate Newfoundlanders and Labradorians about the law and increase access to justice in Newfoundland and Labrador. Our office locations, we have two. We have one in St. John's and we have one in Labrador and Happy Valley Goose Bay. So our services are, we provide public legal information public legal education and information services. So basically, I get paid to travel all across Newfoundland and Labrador and give presentations on all aspects of the law, not just wills and estates, but anything you can think of, I can do a presentation on it and educate anybody about the law. We also offer a legal information line. And what that is it's a phone number that you can call. The number is on your screen right now. It is 1-888-660-7788 or 709-722-2643. Or in Happy Valley Goose Bay, it is 1-709-896-5235. So this legal information line, you call it between 8:30 and 4:30 from Monday to Friday, and you will get a live person or a voice message. And we can answer any questions that you have on the law. If we can't answer it, we will direct you to somebody who can answer those questions for you. If you are tech savvy and prefer email, we also have an email address that you can email your questions to, and that's info@publiclegalinfo.com. Or if you're in Labrador, it's labrador@publiclegalinfo.com. When you do call us, if you don't get an answer, we do ask that you give us 1 business day. The reason being is that there's 2 of us in my position. If I am out doing presentations, then there's only 1 person on the phone and vice versa. So we do ask that you do give us 1 business day to get back to you. The other thing that we do offer is what's called our lawyer referral service. So what that is, it's a 30-minute consultation for $40, taxes in. No legal work is to be completed, so they're not going to appear in court for you. They're not going to write your will, but they'll give you some basic legal advice specific to your situation. Okay, this is provided all across anybody in Newfoundland and Labrador and outside of the province. And it's an opportunity to have legal advice with a lawyer for a really good price. Most lawyers now are charging anywhere from $125 for your first year associates right up to $450 to $500 an hour, depending on experience and type of law. So $40 for 30 minutes is quite a decent deal. So we have about 45 lawyers that have signed up to help us out with this service, and there's no obligation to hire that lawyer beyond the 30 minutes. Okay, and if you wanted to hire that lawyer, then you'd have to have a chat with them afterwards. So a couple other services that we do offer. Number 1 is the Journey Project. This is a joint initiative with the Public Legal Information Association and in Sexual Violence Newfoundland and Labrador. They are legal support navigators who are trained to provide trauma-informed support and general legal information to survivors of sexual violence and intimate partner violence. And that is for anybody from a child right up to people in their 90s and beyond. So it's for anybody and it's for everybody and anybody who has been a victim of sexual violence or intimate partner violence. And their number is on the screen there. It is 722-2805, and you can email them at support@journeyprojectnl.com. We also have our legal rights for newcomers. So this provides legal information and support for refugees, immigrants, international students, temporary foreign workers, or anybody else who is new to Canada and new to the province. It's legal information and support for any issues affecting those newcomers and immigrants. And their numbers are the same as ours, 722-2643, or you can email them at newcomers@publiclegalinfo.com. Now, a lot of people ask me, Sarah, you're legal information, not legal advice. What's the difference? I'm going to tell you. So the difference is legal information. I can provide clear-cut law. So you must be 17 to make a will in Newfoundland and Labrador. That's the law. It is illegal to go 140 in a 100 zone. Those types of things. I mean, it's clear-cut. I can tell you exactly what it is. I can provide you with statutes, laws, regulations. I can tell you where to find them. I can tell you what they mean. And I can also provide you with every possible option to your legal question. So you ask me a legal question and I can say you can do either A, you can do B, or you can do C. Where it gets into legal advice is if I say you can do option A, you can do option B, you can do option C, but I think you should do option A. Option A is your best choice. That's legal advice. We can't do that here at our organization. And I can't tell you how to complete forms or I cannot tell you how to complete forms and I cannot tell you how to fill out your application. What I can do though is that if you bring me an application, I can tell you, okay, so your name goes here, this is the information that goes here, but I can't tell you the specific wordings to use, okay? I can't tell you what words to use. I can't tell you what to argue in a court of law, and I can't provide opinions. So I'm not a judge. I can't tell you that, you know, a judge is going to decide this, or I think a judge is going to decide that. I can't do that, okay? So that's legal advice. So let's get into it. Wills and estates. What is a will? What's an estate? And why is it important? So there are some requirements set out under the Wills Act. Your will has to be in writing. Okay, so that's either handwritten by a pen, by your own hand, or typed up. You have to be at least 17 years of age or older to write a will. If the will is typed, so not handwritten, but typed on a computer and printed off, it has to be signed in front of 2 witnesses. Those 2 witnesses have to be present at the same time you sign the will. They have to be over the age of 19, and they're not allowed to be the executor of the will, and they're not allowed to benefit from your will. So they're not allowed to get anything from your will in order to be a witness. There's no such thing here in Newfoundland as a will via video. We don't do video wills. We don't do audio wills. It has to be on paper. And you must be free from pressure. So what that means is that I can't be sitting next to my mom and forcing her to write out her will and giving me all of her money. I'm not allowed to do that. Anything that you decide to give away in your will has to be of your own mind and your choice, and nobody can force you to write your will. And then you have to have legal capacity when making your will. So capacity is fluid. What that means is that it can change day to day and moment to moment. Generally speaking, it means that I understand I'm writing a will. I understand what I own and what I'm giving away, and I understand who I'm giving those items to. So in order to be considered to have capacity when you're making a will, the things that we're considering are, do they know what they're doing? Do they know they're writing a will? Do they know what they own? And do they know who they're giving their items to? What this means is that if you've been diagnosed with dementia or Alzheimer's, you absolutely still can make a will as long as you understand those 3 things: that I understand I'm making a will, I understand what I own, and I understand who I'm giving it to. So that's what we measure when we're talking about capacity and will making. The important parts of the will. So the first one is the date. So we need to know what the date of the will is, okay? Sometimes you might have drawn up a will 30 years ago, forgot about it, and then you do up a new will and you forget to date it. It's really important to have the will dated because the courts will look at the most recent will, and if the will is not dated, it's not considered valid, and that means that they can't use that will. The other thing that we look for is an executor. This is a person who's going to handle your money, your assets. According to your will, they're going to give out everything that you have named in your will. They're going to have to file your taxes, pay any debts. All of those things is what your executor is going to have to do.
No, I don't want to hear me.
And it's really important to have an executor named because you're going to have somebody to deal with all of the things that need to happen once somebody passes away. The next part that we'll talk about is the gifts under the will. So who's getting what? What are they? They can be small gifts, they can be money, they can be land, anything and everything that you want to give away, you can name in your will. Let's talk a little bit about executors. So executors can be anybody over the age of 19. They can be more than one person. So you can have co-executors. You can have one executor. And it's always good to maybe have a substitute executor named as well. So for example, I name John Doe as my executor, but if John Doe is unable to be my executor, then I'm going to appoint Sally Smith as my executor. So that's a really good idea. Your executor is your legal representative. They handle all of the legal and financial things that happen after you die. So they'll have to file your final income tax. If you have a business, they'll have to close that up. They may have to file lawsuits or fight a lawsuit if somebody disagrees with what they're getting in the will. So your executor would be the person who would represent the estate. Your executor, they have to act in good faith when they're handling your affairs. So what that means is that they need to keep your wishes and the best wishes of your estate in mind. Okay. So they have to ensure that you're not going to lose money unnecessarily. So for example, if I am an executor and I'm trying to deal with somebody's house, and the house could probably sell for say $300,000. But I don't want to deal with having to wait for certain things. I don't want to continue to pay the insurance while it's up for sale. I don't want the hassle of it. And somebody comes along and offers me $100,000. I'm not really getting the best out of the estate. Okay, so you want to make sure that you get, market value for your estate. So some logical and practical considerations. So an executor does have many duties, and it can take a long time to completely distribute an estate. So it's a good idea to select somebody who doesn't need to travel frequently. However, your executor can be anybody living anywhere. Okay, so they don't have to live here in Newfoundland if they're an executor. The other thing that you may want to think about is their background, such as their education or profession. It might be useful when administering your estate because this takes a lot of time, it takes a lot of capacity, it's a lot of paper. So you want to make sure that the person you choose is going to be able to do all of the things that needs to happen when it comes to being an executor. Some other important considerations. You can give power in your will to hire professionals to help manage your estate. So for example, you could ask lawyers or financial advisors or accountants to be your executor. That would give you peace of mind. They do it all the time. However, it does cost money. So you may want to give some thought. If you're thinking about choosing a lawyer as an executor, it is going to cost your estate money or cost your executor money. Okay. The other thing that is a trend that's happening now when it comes to wills is directing your executor to provide an accounting to your family. So for example, I require my executor to provide monthly accounting to my family of my estate while they're going through the estate issues. What this does is it kind of helps prevent the executor from stealing your money, and it keeps everybody accountable. It also shows that your executor is spending the money in your estate wisely for any bills that need to be paid, that type sort of thing. So it's a good idea to do that. So some other additional important considerations. Your will needs to be written in clear, understandable language. So if there's another possible interpretation of what you're saying, it could nullify your gift. So it could make your gift null and void. So for example, you could say, I give my money to my friends. Okay, so what's the problem here? How many friends do you have? As soon as you say, I give money to my friends, you're going to have a lot of friends coming out of the woodwork saying, oh, I'm your friend, I'm your friend, I'm your friend. So you want to be very specific. So you would say, I want to give my money to my friends, John Jacobs, Sally Smith, and the list goes on. Okay, so make sure you name the people that you want in your will. And then be as specific as you can to clearly identify what you're giving away and to whom. So for example, here I give one of my cars to my brother Jack. Okay, well, which car? So a better example would be I give my 2009 Hyundai Elantra to my brother Jack White of the town of Makovic, Newfoundland and Labrador. There's no issue there with, okay, well, I don't know what car he's going to leave and I don't know which brother. So it's very specific, okay? So be as specific as you can to clearly identify what you're giving away and to who. Your contents of your will, so personal property, so that's anything that you own. Okay? Anything. Tools, jewelry, sentimental items, artwork. If you have special clothing, whatever it is that you want to get rid of, give away, that's your personal property. Okay? Your real estate and land, so the family home, maybe a cabin, anything like that, you can give away as well in your will. However, it is important to consider who you're giving that to and how many people you're giving that land to. Okay, because we want to try to prevent arguments, and the best way to do that is to be very specific. You may want to put restrictions on that land, like I don't want you to sell it because I want to keep it in the family because it's been in the family for years. Those are the things you want to think about when it comes to naming real estate. And then money versus percent of the estate. So be aware that if you say, okay, I'm going to leave $100,000 to somebody, you may not have that by the time you pass away. So the trend now is to give a portion. So I'm going to give 10% of my estate to whoever you want to give it to. One of the most important clauses that we have is called the residuary clause. And that is the clause that determines who gets everything else. So for example, you've specifically listed your some personal property items. You specifically listed who's getting your house. You've specifically listed a certain portion of money. But then there's all the rest of the things. So this residuary clause determines who gets everything else. So it can be expressed as a percentage of the estate. So for example, I give all of my remaining assets to my sister Jackie of the town of Twillingate, Newfoundland and Labrador. Remaining assets cover things that you didn't specifically give away. Or I give all the rest of my estate or my remaining assets to be split in the following ways: 25% to my sister Jackie Burns, 25% to some charity, 25% to somebody else, 25% to somebody else. You can split up the residuary clause however you want, as long as it adds up to 100%. If you don't have this clause in your will, or if there's something not disposed of in your will, it falls to what's called the Intestate Succession Act. And that is divided among surviving family members according to a formula. That formula, generally speaking, is usually spouse. If no spouse, then kids. If no kids, then parents. If no parents, then siblings. And it goes on down the line until they can find somebody that's related to you that's entitled to any remains that you have. So some special considerations: matrimonial property. So the assets that you own with your spouse. The Family Law Act allows a spouse to apply to the court for 1/2 of those shared assets when a spouse dies, if there's no will. Even if there is a will, the spouse is entitled to 1/2 of the assets. What that means is that you can't write out your spouse. You can't get mad at your spouse and say, I'm leaving my spouse nothing. Okay. Because they are provided for under the Family Law Act. It protects them. It protects them from, being booted out of their house. However, this only applies to married spouses. You have the piece of paper, you had a civil ceremony or a church ceremony, you got the ring, you got the piece of paper. That's it. It applies to married spouses. It does not apply to common law partners. There is no provision in the Family Law Act or the Intestate Succession Act for common law partners. So if you are living common law, it's really important to have a will done to include your common law partner if you want your common law partner to have any part of your estate if you pass away. The other thing I will mention is the actual home that you live in with your spouse. If you are married and own your home, the spouse will receive title to that home in the event of death. This does not apply to common law partners as well. Okay, so your common law partner, if you bought a house and common law partner is not on that deed and you pass away, that common law partner is not entitled to that house, even though they've lived there for years. So again, really important if you're living common law to make sure you have a will done, including your common law partner. Joint bank account. So if your spouse dies with a joint bank account with you, often there's nothing needed to be done for you to access your jointly held money. So for the majority of times, if I have a joint bank account with my spouse dies, I can still access that money. There's nothing I really need to do. If the money is held in a joint bank account with your child or somebody else, a lot of times we'll see people have joint bank accounts with their adult children just to help them out with the day-to-day banking. That money might not be considered money for your child. So what the banks will look at is the intention of the people that had that bank account. Okay, so that bank account potentially could be frozen until the court determines that, yes, that child who was on that joint bank account is actually entitled to this money.
Can I ask a question here?
Not right now, Ramendra. You're going to have to put your question in the chat box, please. Okay, carry on, Sara.
So some other considerations that you might want to think about when you're doing up your will. You can list in the will for the care of minor children or adult children who are dependent on you. So for example, adult children who are disabled. But this is subject to approval by the court. So the courts will look at the best interests of the children and look at the best interests of that adult dependent child. Okay. But they do put very heavy weight onto the will and what you have said in your will. I have noticed that when I was working in the courts that they did put a lot of weight onto the wills. Marriage. If you get married, your original will is null and void unless you have steps to make sure it's still valid. So what that means is that if you do up a will in contemplation of marriage, then that will be valid. But the majority of times, if you get remarried, your original will is null and void. However, if you get divorced or you separate from your spouse, it doesn't affect your will. So you'll likely want to review and make changes. Okay, so you may want to make changes if you wind up getting divorced or separated. The death of a beneficiary. If the beneficiary dies, the gift to them may be canceled and the property becomes part of the residual estate unless there's a specific provision in the will. So a lot of times what you'll see is, say, for example, I give all of my property to be split equally among my 2 children. If one child dies, then their portion could potentially go to the surviving child unless you specifically state. So the most common one I see is I give my estate to be split equally among my children. If one of my children dies, I want their portion to go to the grandchildren. So that's the most common one that I do see. So some other estate planning considerations, your digital assets. So we all, like a lot of us have emails, a lot of us do online banking, a lot of us have social media accounts. We have digital artwork potentially, maybe some intellectual property there as well. So give some thought as to what you want done with those once you pass away. Social media should really be a consideration. You may want to leave a note with, you know, your account information with somebody so that if something happens, they can go in and deactivate your account. That would decrease fraud and illegal activities. I was telling a group today that one of my family members who had passed away about 6 years ago, we didn't know that they had a social media account. Like we just forgot about it, as you would. We forgot about their Facebook account. And they started messaging us there this week. It was spammers trying to get some information, but it was a bit of a shock at first to realize, oh, okay, we know this person has passed away. But then when we realized it was scammers, we kind of got really, really angry. But just be aware that, you know, leaving those accounts open can cause some really, really bad fraud there. So just be aware of that, okay? Just give some thought to your digital assets and what you want done with them. So there's no reading of the will unless it's specifically put in the will or the executor decides to read the will. So what that means is that you'll often see on TV, they have a funeral and the person is not even buried and they go to the lawyer's office, the lawyer opens up the will and reads it. We don't do that here. There's no need to do that. In fact, the executor is required to keep the will private, including from family members. Common law relationships mean you are not entitled to anything under the law, no matter how long the relationship was. You don't need a justice of the peace, a lawyer, or a notary to witness your will or be part of your will in any way. When it comes to the witnesses, they need to be over the age of 19. They're not allowed to be a beneficiary of the will. They're not allowed to be your executor. And as I said, diagnosis of dementia or Alzheimer's does not always mean you can't make a will. So you need to understand that you're making a will, what you own, and who you're giving it to. So why have a will? It's peace of mind for you. Okay? It lets your wishes, it makes your wishes known. It allows you to choose who's going to handle your financial affairs. So it allows you to put that trust and control into your hands. And it allows you to choose how your financial affairs are handled. So it allows you to choose how you want your estate divided. It can also maximize your estate's financial wealth as well. By having a will, it's much cheaper to deal with a will than it is to not. It takes stress away from your family and friends as well. Because once they have this will done and it's probated and everything is so much easier to work with, and they know what your wishes are instead of trying to figure out, oh, well, what would a mom wanted done with this? What did dad want with that? Okay, so it's really good. It takes that stress away in a very stressful time. So a lot of times people say, oh, nobody needs insurance. Or, no, I don't really have anything. Like, I'm not a millionaire. I don't need a will. You know, it's nice to have when you do need it. So it's like insurance, right? And then consider if you inherit something later in life. It's always good to have that will in place beforehand. Or, you know, if your family changes in later years, maybe you decide you want to leave something to somebody, you can do that. The big things though are somebody's going to have to pay up your final debts, handle your estate, wrap up your estate, pay your income tax returns, apply for your death benefits, handle any other expenses. So it's really important to even just name an executor, because that person will be the person who's going to be able to do those things on your behalf, on your estate's behalf. And it's much easier to have an executor do that than to try to figure out under the Intestate Succession Act who actually has the priority and who is allowed to be the administrator of the estate. So if you name an executor, it just makes things much, much easier. So I noticed some questions in the chat.
Okay.
Yeah. As an executor of a will, can I make the decision to hire a lawyer to carry out the wishes of the will? Yes, you can. However, the estate may or may not pay for that lawyer if you as the executor make the decision. That's on you, and that would come out of your own pocket. However, if you state in your will, I have so much money put aside to hire a lawyer, or I want you to hire a lawyer, if it's specifically stated in the will like that, then it would come out of the estate. Can the executor be a beneficiary under the will? Yes, Wayne, they certainly can. It's very, very common. Is it advisable to leave your home or property to your children, or is it better to state as to be sold at market value and proceeds divided among the children? Callista, that really depends on your family situation and how you think your children are going to deal with that. It really depends. I can't give you a specific answer on what is better, because what's better for you might not be better for me. Okay, and especially if there's property that's been in your house, in your family for 100 years, maybe you want to keep that in the family instead of being sold. Dorian, there's no will and trust. That's an American thing here. We don't do that here in Newfoundland. When you say marital home goes to the spouse, does this apply even if the surviving spouse's name is on the deed? If you are married, yes, it does, Don. If my husband legally married dies before me and there's no will, are his possessions mine? Would I be the automatic executor if we have, okay. 2 questions there, Tracy. You are, if he has no will, you are entitled to 1/2 of those assets. So under the Intestate Succession Act, there is a formula there that the surviving spouse gets 50% of the estate, and then the rest is split among children if you have children. If you don't have children, then you're entitled to all of it. If you are, would you be the automatic executor if we have a will and only one of us dies? No, your executor has to be named. So for example, my mom might name me as the executor and not my dad. That's perfectly okay. So it's not automatic. You won't be the automatic executor if you have a will. Does one name an executor? So in your will, when you do a will, you would say, I name John Doe as my executor to take care of my estate. If John Doe's not able to do it, I appoint Sally Smith to be my executor. And no, it does not have to be done through a lawyer, not at all. My present will was made by a lawyer. Now I want to make changes. Can I make a new will myself? Do I need 2 witnesses? My executor is one of my beneficiaries. So, okay. Question number 1, can you make a new will yourself? Yes, absolutely you can. Do you need 2 witnesses? Yes. Over the age of 19, they're not allowed to be your executor. They're not allowed to be your beneficiary. Your executor is one of your beneficiaries. That's fine. That's really common to have an executor as a beneficiary. That is very, very common. If you leave your home to your children, would they have to pay capital gains tax? No, they will not. If you have a prenup agreement and make a will, would this mean that your spouse gets 50% of the estate, or would it go to according to percentage in the will? Marilyn, I'm not really sure what you, so prenup deals with you while you're living, so that doesn't really matter. If you pass away, your spouse is entitled to 50% of your share of the estate. Wayne, can you have more than one executor? Yes, you can have a co-executor. That's fine. Can you write up a codicil to your legally drawn up will yourself, write or handwritten? Calissa, yes, you can. Your codicil, so for those who don't know, a codicil is an amendment to a will. It's a change, okay? When you do a codicil, the same things apply. It has to be dated, it has to be signed, and it has to be witnessed by 2 people. Okay, and then that will go with your original will. But yes, you can certainly do that yourself. Property outside of Canada, is that automatically considered part of your assets in your will? Yes, it is. However, if you have property outside of Canada, please speak with a lawyer to figure out the legal implications of that property. The question is about somebody leaving your home to someone other than children. Is there capital gains tax for the person receiving the home? No. If an automobile is left, do the wife get the vehicle without the will? That depends, John. It depends. So if you have no will, your spouse is entitled to 50% of your estate. That really depends on if there's money owing on the car, a whole bunch of things. Is there a provision for executor fee in Newfoundland as say in Ontario? So you can ask the court. This is one of those things that is very different here in Newfoundland. So Ontario states that an executor is entitled to, I think it's about between 5 and 10% as a executor fee. Here in Newfoundland, there's no set fee for an executor. You have to ask the court if you can take a fee as an executor. Okay, so here in Newfoundland, you have to ask the court. They usually say yes, and generally speaking, in a lot of cases I've seen, or you can actually specifically put that in your will as well, George. So here in Newfoundland, you can specifically say, I direct my executor to get 5% of my estate as a fee. You can certainly do that. That's perfectly okay, and I've seen that happen a lot as well. If you leave land with a condition not to sell, is that condition enforceable? So, yes and no. Is that condition enforceable? No, not really, because if you leave the land to somebody and it's theirs, they can do whatever they want with it. But you would have that conversation if you wanted to leave it in the family. You would state that I would prefer that it's left in the family or want it left in the family. There's lots of different ways you can write a provision, but no, it's not hardcore enforceable. Once you give that land away and that land is gone, they can do with it whatever they want. If you have property in 2 or more provinces, should you engage lawyers in each province? For what purpose? In order to divest the property, you are going to have lawyers in each province, but to do up your will is fine wherever. So when I say one spouse dies, the other gets 50%, does that apply across all circumstances or only if you have children? For if we have no children, does the surviving spouse legally married get everything? If you have no will, I'd have to check the Intestate Succession Act, Tracy, because I'm not 100% sure on that. I think that is correct, but I'm not 100% sure. Because that act is there's a formula, you have to go through it, all that. In order to protect yourself, if you want to make sure your spouse gets everything, do up your will saying that you want your spouse to get everything. Your 3 children are executors on your will, but you only want one child to be the sole executor. Will a handwritten letter cover this? Harold, as long as it's dated and you say that you're making a change to your will, and that you're taking out your 2 executors and you're having one person as your executor, yes. Make sure it's witnessed. If you have a will from New Brunswick, is it valid in Newfoundland? If the will is dated, has an executor, and is witnessed properly, then yes. Oh, 1 payment owed on the vehicle. So if there's still a payment owed on the vehicle, that payment would have to come out of the estate in order to pay off that debt. And then you would have a discussion with the car company to see if, that person is going to take over that car. No, I said you don't need a notary to witness and sign your will. Your witness has to be somebody who's over the age of 19, who's not your executor and not your beneficiary. So you don't need a notary or a lawyer. Can you leave 100% of your house to someone other than your surviving spouse? No. The Family Law Act will not allow for that if it's your matrimonial home. So if it's a home that you live in with your spouse, the Family Law Act will supersede that and say, no, that spouse is entitled to that house. If you leave your house to 3 children, can you stipulate that they cannot sell it? They must keep it in the family name. You can stipulate that, absolutely. My husband has land, only his name, but he has a will naming me as beneficiary. Will that be sufficient, or should change land to both your names? Harold, no, if you are named as the beneficiary, that's sufficient. That is sufficient, yeah. Okay, good questions. Moving on. Enduring powers of attorney. So, power of attorneys are legal documents that give somebody else the legal authority to act on your behalf in relation to finances. Okay. Lloyd, no, no, your spouse, you can't have, okay. Oh my goodness, more. Hold on. Can you and your spouse make a will together? No. If you have a matrimonial home that you live in and also a cottage, is a cottage considered a matrimonial home? It's not considered the matrimonial home, it's considered matrimonial property. There's a difference. So the matrimonial home is a home you live in with your spouse. The matrimonial property are all the assets that you own together. Your will is 30 years old, doesn't matter how old it is. Harold, no, that doesn't matter. But a lot can happen in 30 years. So I do suggest every 5 to 10 years, or if there's a big change in your life, that you take it out, look at it, and see if everything is still the same, or see if you want to make some changes to that. If your spouse agrees your house can be left to your children only and not his children, the house that you guys live in would be considered his. You can write it in the will stating that you want to give it to somebody else, but there could be some argument there. So are the online wills, like willful, sufficient? Those wills have to be printed off and signed and dated and witnessed. So yes, they're useful, but they need to be printed on paper. They need to be witnessed by 2 people, and they need to be dated. So that's really important. You can't just store it electronically. It has to be a hard copy with your inked signature on it. Is there any circumstance where a surviving spouse can be written out of a will? No. No, the Family Law Act will allow for the surviving spouse to get part of that. Probate required on joint bank accounts when beneficiaries are the joint bank account holders. Charles, that depends on your bank. I'm seeing it more and more where probate is required on joint bank accounts, but again, that's something you'd have to ask your bank specifically. So let's talk about power of attorneys. And I'll check questions in chat in a little bit. Oh, sorry. So your power of attorney is, like I said, it's a legal document that gives somebody the power to make financial decisions while you're alive and while you still have capacity. So I'm appointing somebody as my power of attorney because I just don't want to deal with finances. Okay. This can be granted for a specific period of time or specific tasks. So for example, if somebody's working on a turnaround, they're in the middle of selling a house and they don't know when the closing date is, they might be gone for that closing date. They can actually just appoint a power of attorney for that specific thing. I appoint a power of attorney to sign those documents that need to be signed. Or it can be very general. You can have a general power of attorney. I appoint John Doe to be my power of attorney and take care of my money for me. Okay. An enduring power of attorney, though, this is a little bit different. This endures beyond a person losing capacity. So all of a sudden, I can't make financial decisions by myself. I have lost capacity due to, I don't know, say I have Alzheimer's, and now I'm to that point where I can't make those financial decisions. This only deals with financial matters such as banking, taxes, paying bills. It doesn't involve decisions about healthcare, okay, or the treatment or authority to deal with a person's estate after they die. So it's meant to be exercised after the person granting the power of attorney loses their capacity. So this gives somebody else the authority to handle your finances if you don't have the capacity to understand the effects and decisions related to finances. So this follows the rules of the Enduring Power of Attorney Act. You have to have legal capacity to create this. So what that means is that I understand I am writing an enduring power of attorney. I know who I'm appointing to be my power of attorney to act on my behalf. Has to be signed by me, the person making the enduring power of attorney, as well as an independent witness. So that witness is over the age of 19 and is not the person I appoint as my power of attorney. This comes into effect upon legal incapacitation. So that means that I've lost the understanding about my finances. I'm not able to make financial decisions by myself anymore. And who decides you're incapacitated? Usually a doctor. And it can be revoked as long as you understand that what you're doing. Okay, as long as you have the capacity, you can revoke this enduring power of attorney. So who can act? Anybody over the age of 19 can be your enduring power of attorney. You can appoint a trust corporation or an accountant, but they're going to charge you fees. You can place restrictions with your enduring power of attorney. You could say, don't sell my home because I own it and it's under my will. You can do a whole bunch of things like that. And the big thing that we do suggest, and the thing that I have seen now, is when you do your enduring power of attorney, require them to make annual or monthly financial reports to your children or other family members. This keeps your enduring power of attorney accountable, and it gives peace of mind to your family, knowing that the money that the enduring power of attorney is spending is going towards your bills and your care and what you need, and not to the power of attorney themselves. Some things to consider. If you own a business, who's going to handle it when you can't? Maybe selling your home. Do you want your home to be sold? Who's going to sign that agreement? And it's always good to have a backup. So who is going to take the place of your attorney when your attorney can't for some reason? So why have one? It's insurance for when you're maybe in need. You can pick who you can act when handling your financial affairs. It can take stress off of your family and loved ones, and it prevents family fights and legal bills. So sometimes if you're unable to make financial decisions, your family wants to start paying your bills and they can't because the banks won't talk to them because they're not appointed as your attorney. So the attorney has to act in good faith to protect your best interests. So for example, I can't take your money and go to Florida with it. I have to spend the money for your financial gain, not for my financial gain. I can do pretty much anything with your estate if I'm a power of attorney, but I have a requirement to pay any outstanding bills. I have a requirement to pay any taxes. I have a requirement to use that money for you and not for me. And I can also hire professionals to help manage the bank account, but again, they'll take their fees. So why have one? So it's going to give the ability to for someone to help you during times of need, so times of immobility. It allows someone to access your financial affairs when you're unable. So for example, if you're in a coma or you have dementia or Alzheimer's, and you can't make decisions for yourself, but you still have things that need to be done. You still have bills that need to be paid. Having enduring power of attorney is going to make sure that everything is continued on so that you're not going to go into debt or anything like that. It's going to make sure that your bills are being paid. It allows you to choose who will help you in times of need. So this is going to, you're the one who's going to pick somebody that you trust to take over your financial affairs for you. And it allows you to choose how your finances are handled. So this is where you can put restrictions on your property, on your finances. So what isn't a power of attorney? It's not a will, okay? This power of attorney will stop the second you pass away. So once you pass away, your power of attorney no longer works. So they can't act for you anymore once you pass away. And the power of attorney gives no right to do anything under the estate of a person. So what that means is that I can't dictate like giving away your stuff. Okay? It's only dealing with finances. So if you don't have a power of attorney, you'd have to apply for guardianship. Somebody's going to have to apply for guardianship over you, and that's very, very hard and very expensive. So a power of attorney provides opportunity for you to appoint somebody to help when you're in need while you still can. And if you don't have one, somebody must be appointed by the Supreme Court of Newfoundland and Labrador through what's called guardianship. Guardianship is expensive to do. It has at least 8 forms. More than likely, it's usually about 10. And there's no guarantee that somebody is going to come forward to be your appointed guardian. Okay. And there's 2 types of guardianship. There's one of the person, that's all the social and medical decisions, but we're going to talk to the financial decisions. Okay, so guardianship of the estate is equivalent to a court-ordered power of attorney. And it only provides powers to handle finances. So for example, to pay your bills, to file your taxes, collect and deposit your checks. It doesn't concern medical or social decisions. So if I'm a guardian of the estate if I'm a guardian of the estate of somebody, I can't tell you that I'm putting you in a home. I can't tell you you're going to bingo, and I can't do any end of life decisions at all. Okay. So guardians are appointed by the court. Here's the thing, your enduring power of attorney can be anybody, anywhere, but a guardian has to live here in Newfoundland and Labrador. Okay. They have to act in good faith. So again, same sort of thing applies. If you're a power of attorney or a guardian, you have to act in good faith. You have to use the money for the person you're taking care of, not for your own gain. And guardianship can be revoked by court application if somebody decides, I'm going to take the money and run. So somebody else would have to, go after them for that. So if there's no guardian and no power of attorney, so you might be okay in the short term, but you'll have nobody to care for your finances. So there'll be nobody to file for your taxes. There'll be nobody to make sure that you're getting, the most of your CPP or your pension benefits or anything like that, right? So it's open-ended as to what can happen. And if there's no guardian, it could be an opportunity for elder financial abuse as well. So I have heard stories and we've gotten phone calls of somebody collecting pension and CPP checks and then cashing them. Well, mom is struggling because she's in a home and she needs XYZ and there's no money. All of a sudden the money's gone. So really important to have an enduring power of attorney appointed, so that when you do lose capacity, or if you lose capacity, there's somebody there that's going to be able to take care of you, okay, and take care of your finances. So I'm going to check the questions there now. If the will says up to 10,000 to the church, does the estate have to pay 10,000, or can a lower amount or no money be considered? So this is where, this is where you need to be really specific as to what it is you want. The up to 10,000 is a little bit sketchy there. So you'd have to be very specific. Do you want to leave $10,000? Do you want to leave 10% of your estate to a maximum of $10,000? That would be, you know, you got to be really specific there. Yeah, Kevin, you can stipulate capital gains on the cabin be paid out of the estate. If you have 1,000 shares in your company, can you leave it all to your children, not your spouse? Yep. Did I say power? No. Power of attorney can be anybody, anywhere over the age of 19. What's the difference between an enduring power of attorney and a guardian, or are they interchangeable terms? So your enduring power of attorney is somebody that you appoint while you still have capacity, so that they can kick in when you lose your capacity. The guardian is somebody that the court appoints because you didn't do a power of attorney and somebody has to step forward. And that somebody, there's a formula there about who gets priority to apply to be your guardian. And that might not be the person that you want. So they're two different things there. The enduring power of attorney is something that you choose, and they have more power. Your guardian is somebody that's court appointed, and it might not be the person that you want. If you have a will drawn up that specifically states where my money and assets go, but have outstanding bills and loans, do the loans and bills get paid out of your assets first before anybody else? Yes. That is correct. So if you have a will done up and you have outstanding bills, the loans and the bills get paid out of the assets first. If there is not enough money available to cover your bills and loans, can they sell your assets to pay off your outstanding debts before anyone in your will gets anything? Yes, they can, and they will do that. Okay, so the first rule of thumb is you get your debts paid off first, whatever is left over gets divided. As with the joint executor for a will, can there be joint power of attorneys? Yes, there can be, Charles. Yep. Is my married spouse automatically your enduring power of attorney? No, they are not. Not at all. So if you want your married spouse to be your enduring power of attorney, you will have to do up an enduring power of attorney, naming your spouse as your enduring power of attorney. End of life decisions, that's a completely different thing, Ralph. That goes into the advanced healthcare. Who prepares the final tax return? Your executor will prepare your final tax return. And is the estate responsible for any outstanding taxes with CRA? Yes. Capital gains aren't a thing here in Newfoundland. So enduring power of attorney, so there are samples online. We have a sample. If you go to our website, we do have a sample of a enduring power of attorney that you can take a look at. Yeah, so when you talk about capital gains aren't something that you do when it comes to gifting. So if I gift something, then it's not a capital gain. Denise, no, I can't share my PowerPoint. But what I can do is I can send a copy of our legal planning guide, which has everything in here that I'm talking about. So life insurance, you have to name if you don't name a beneficiary for your life insurance, it goes to the estate. And if it goes to the estate, then it will go to pay off any debt. I'm going to put our website in the chat, publiclegalinfo.com, that has a lot of really good information on wills and estates. Is there a cost? Is there a cost to identifying a legal enduring power of attorney? I don't understand the question, Tracy. If you're getting a lawyer to do a legal power of attorney, then yes. There is a cost to writing that up, but there's no cost to having that property, or there's no cost for that power of attorney to be your power of attorney. If you have a second property and you gift it to your children, are you saying there's no capital? It's a gift. It's a gift and there's no taxes on the gift. Does the government take your property if you have no will? No, they do not. Okay, Tracy, thanks. That answers your question. Yeah, good.
Okay, Sarah, I think we've gone. Did you cover all the points you wanted to cover tonight?
I wanted to talk briefly about advanced healthcare directives.
Oh, okay. We're
If I
still
have
good
time.
for,
We're
yes,
still good?
we're still good for a little while. Yeah.
Okay. Alrighty. Let's move on to that. Power of hold on. Power of attorney versus going and having a lawyer draw that up. So you can find copies of all of these documents online. What I will say is that please make sure that what you find is from Canada and not the United States. I've already talked about capital gains. I'm not going to talk about it anymore. I've bet that to death, so I'm not speaking about that anymore. Yes, so I just posted in the chat our website.
Session is being recorded.
The session is being recorded, so if there's any questions or you want to go back, you certainly can.
Okay.
My information is still here as well. You can certainly visit Public Legal Info, and you can request hard copies of our publications as well. If you want a hard copy, you can certainly request that and we can send it out to you.
Sarah, maybe go on to the
Yeah, will do.
next part. Yeah.
Okay. So advanced healthcare directives. So this is a document that allows an individual to give instructions about their future medical care. And it can also designate a substitute decision maker for when you're unable to make your healthcare decisions. So this comes into effect. We talked about the enduring power of attorney deals with finances. This is dealing with my health, okay, and my medical choices. It comes into effect and only remains into effect when I don't have capacity or I'm unable to communicate my healthcare decisions. So if you don't have a substitute decision maker appointed, so you don't have an advanced healthcare directive and there's no substitute decision maker, there is an act, the Advanced Healthcare Directive Act, which sets out a list, again, according to priority, of who is asked to act as your substitute decision maker. So what that means is that usually it's spouse, if no spouse, then children, and it goes on from there. There is no provision in this act for common law partners. Again, so what we have seen is sometimes a common law partner wants to, make those healthcare decisions, but under the Healthcare Directives Act, it's the children who has that priority and not your common law partner. So really important to have these documents in place if you're living in common law. Your Advanced Healthcare Directive, you can actually list people who you don't want to be your substitute decision maker. And there are a lot of reasons for that. So you can specifically state who you don't want as well. And it also applies if you haven't made an Advanced Health Care Directive. The only thing is that there's a formula as to who they're going to choose as your substitute decision maker. So, found in the Advanced Health Care Directive Act, you have to be 16 years of age or older. You have to understand that you're doing a healthcare directive and who you're appointing and what your healthcare wishes are. So this document, it has to be in writing, like everything else that we've talked about, has to be a hard copy in writing, signed by you and the person you appoint as your substitute decision maker. Okay, they need to be aware of this and they need to agree to your decisions, as well as 2 independent witnesses. So you also need 2 witnesses to sign this as well. So your substitute decision maker, they are responsible for communicating instructions in the directive to healthcare professionals. And when necessary, they will make those healthcare decisions on your behalf. Your instructions can be as broad as I direct my substitute decision maker to make any and all healthcare decisions when I'm unable to, or you can be very, very specific. So you could say, if I have this diagnosis with this prognosis, this is the type of care I'm looking for. If you are getting into specifics like that, I do suggest you speak to a healthcare provider because they would be better suited to tell you what some specifics are. I'm not well versed into every little situation that can happen in a hospital and every little diagnosis and prognosis. So if you're interested in going really specific, I do suggest you speak to a healthcare provider, nurse practitioner, or public health, something like that, who would be better suited to answer those specific questions. But like I said, you can be as broad or as specific as you want. There's 2 times this Advanced Healthcare Directives doesn't apply. Emergency treatments. So, treatments that you're made an emergency and they can't find your decision maker, or there's a delay in trying to contact your decision maker, can cause additional harm. They're going to treat you to preserve life until they can actually reach your substitute decision maker. And then involuntary psychiatric treatment. So if you are detained involuntarily to a psychiatric facility, your Advanced Health Care Directive does not apply. However, there will be a patient advocate appointed, and they will work with healthcare professionals and you as well. So is there any questions on the Advanced Health Care Directive? Check in the chat here. Okay, so as you can see on the screen, I have my email address, Sara@publiclegalinfo.com. We have our phone numbers, 722-2643, and we have our website, www.publiclegalinfo.com. So if you have any questions at all, you can reach out to me, you can reach out to the phone number, anything, and everything. We'll be happy to talk to you. If you are in a community anywhere in this province and you think this would be a good presentation to deliver to some of your friends or family members, we can certainly arrange for that as well. Like I said, I'm all over Newfoundland and Labrador all the time, and I love visiting and meeting with people. So please reach out to me if you have any questions at all.
Okay. Sara, I don't know what I can say at this point in time, except a huge thank you
Oh, you're welcome.
from everybody on the call tonight. This has been a very productive evening, and you certainly covered a wealth of information in a very short period of time. I think if nothing happens from tonight, but people on the call who may not have a will or have considered some of these recommended courses of action, that they themselves go and take those actions, because it is just the right thing to do to have everything in place. So I want to thank you for your presentation. I want to thank everybody on the call for your interest in this discussion. Thank you, Wayne, for your introductory remarks. Thank you to Leona with Provident 10. I think, Leona, this has been hugely successful, and I look forward to what we will probably be doing together for the next round of information for all these fine people who took the time out of their evening to be here tonight. So, Leona, final word?
No, I just want to say thanks. It has been super productive. Sara, thank you so much. Really informative. I've got a couple of notes that I'm taking away, and I've got an action. I have to action now myself. So, and Sharon, I'll be in touch.
Okay, wonderful.
Thanks,
Well,
everybody.
again,
Have a great
thank you.
evening.
Thank you,
Again, thank you,
everybody.
Sara. Again, everybody, and good night.
Okay, bye.